a cikin wani lokacin su ganga ko kuma mota ne ba.
About council. Any
Yes, my
appeal?
lord.
Amma da
Yes,
ko wani kofin su da
Yes,
lafiya su
ma'am.
kofin su da ran abu da shi ta bayan su.
may I please, my lord.
Yes, please.
Aminu Saidu.
Aminu who?
Saidu, my lord.
Aminu who, please?
My lord, Aminu Saidu, my lord.
Saidu.
Yes, my lord.
Yes.
Appearing for the claimant. My lord, the matter is today for judgment.
Yes, the matter is for judgment. The court will proceed to deliver the judgment.
As
Ci gaba da
court
ga wannan kofi.
Confirm that hearing notice has been served on the defendant. Fortunately, we have no power here, so I'm reading from the laptop, and I will read the introduction and claims, and
As court,
to the issues raised by the defendant in final written address and proceed straight to the decision of the court. So that's how we are going to go about it.
as court pleases.
So the claimant filed this action against defendants via the form of complaint dated and filed 5th day of July 2019 and seeking the following reliefs. A declaration that decision of the first defendant contained in letter of 27 March 2019 titled dismissal under the hand of Nnamdi Morris Mberi, permanent secretary to the commission purporting to dismiss claimant from service of Nigerian Police Force effective 27 March 19 for misconduct being in breach of claimant's right to fair hearing under section 30 sub 1 1999 Constitution, Federal Republic of Nigeria as amended, the Police Act, Public Service Rules and Police Regulations is unconstitutional, unlawful, null, void, and of no effect whatsoever. 2. Order setting aside the decision of the first defendant contained in the said letter of 27 March 2019, purporting to dismiss the claimant from service of the Nigerian Police Force with effect from 27 March 2019 for misconduct. 3. Declaration that claimant is yet a chief superintendent of police in the employment of the Nigerian Police Force and entitled to remain so without prejudice with promotion and or increment in accordance with extant regulations until his appointment is lawfully determined in accordance with terms and conditions governing the said appointment, including due process as prescribed by 1999 Constitution, Police Act, etc. 4. A declaration that claimant is entitled to all his emoluments and entitlements, allowances and other privileges of his employment and rank in the service of Nigerian police until the said employment or appointment is lawfully determined. 5. Mandatory order directing defendants by themselves, servants or agents to grant, avail, and pay to the claimant all accrued and no accruing salaries, emoluments, benefits, allowances, etc. from 7th March 2019 until judgment and satisfaction thereof. 6. Order of injunction restraining defendants by themselves, their servants or agents from interfering in any way or manner with the claimant in the performance of his duties and or withholding his salaries, emoluments, entitlements, promotion until his appointment is lawfully determined. 7. Cost of action. And 8. And such further orders as court may deem fit to make in these circumstances. Claimant filed complaint along with his statement of facts and other required processes as prescribed by the rules of this court, which were all served on the defendants. But defendants did not enter appearance nor filed any processes in defense of this suit, despite several hearing notices served on them. In line with Order 9, Rule 5, Sub Rule 1, and 38, Rule 2, Sub Rule 1 of the rules of this court. This court commenced trial on 20th March 2020 with the claimant as the sole witness who testified on his behalf as CW1. He adopted his written witness statement on oath dated 5th day of July 2019, while documents tendered were admitted in evidence and marked as Exhibit CA1 to CA16. The matter was then adjourned in accordance with Order 38, Rule 2, Sub-Rule 3 of the rules of this court to give defendant the opportunity to cross-examine the claimant. Defendants were not in court on the 5th day of February 2021, and no counsel was also present in court for the defendant, despite hearing notice served on them. Defendants were on the 11th day of May 2021 by an order of this court foreclosed from defense in accordance with 38 Rule 9 of the
Amma
rules of
bai data ba. Okay.
and claimant counsel thereafter ordered to proceed and file in line with Order 38 Rule 2 Sub-Rule 4 of the rules of the court. The final written address of claimant is dated 19th day of June 2021, but filed 23rd day of June 2021, via an application of dated 19th June 21, deemed filed on 18th day of February 2022. Final written address was adopted before this court on 30th day of March 2022. It is also necessary to mention here that the proceedings of court were done virtually due to COVID-19 pandemic. It is the case of claimant that he was enlisted into the Nigerian Police Force on 1st day of July 1992, appointed as Cadet Assistant Superintendent of Police, effective 1st day of 2000. He rose through the ranks as Assistant Superintendent of Police and Chief Superintendent of Police in 2016. He enjoyed all the rights and privileges thereof. That among several postings, he served as the Commandant Police Training College, Sokoto, and then as State Armorer, Sokoto State Police Command. That he was served with several queries for serious misconduct, to wit, disobedience to law orders, dereliction of duty, sabotage, and general misconduct to the scandal of the public, gross insubordination and conduct prejudicial to discipline. Contrary to Chapter 4, he stated that he replied the queries, but were two separate investigation reports, wherein he was exonerated in the one dated March 6, 2014, but was not privy to the one dated March 18, 2013, to the Assistant Inspector General of Police, Zone Sokoto, and Commissioner of Police, Sokoto State Command. He averred that he did not hear from the defendants following the allegations in the respective queries on him, not until 3rd day of April 2013, when he was served with query for serious misconduct from the Office of Second Defendant on accusation of bribery, corruption, falsification, negligence, and acts unbecoming of a police officer, to which he provided explanations. That he was directed to appear, and he did appear before the First Disciplinary Committee at Abuja in connection with the several allegations against him, but was not informed of the allegation he was required to answer before the committee, not availed the opportunity of seeing or hearing the evidence, oral or documentary, against him, of any witness who may have testified against him, and or examining any documents, including the 2 reports of criminal investigation conducted, which may have implicated him for any misconduct. That a fresh allegation of corruption was leveled against him by a member of the Fourth Disciplinary Committee, completely different from those he was confronted with in the various query letters, and was excused to leave thereafter without a hearing on any of the several allegations of misconduct for which he was queried, or that might have informed his arraignment before the FDC. He stated after returning to his station at Sokoto to resume his normal duties, he received a letter of dismissal from the first defendant dated 27 March 2019, premised on grounds of sundry misconduct under 030302, 030307 of Public Service Rule, and a reduction of his rank also from CSP to SP. That the defendants failed to consider stipulated in the Police Act, Public and the Constitution, Federal Republic of Nigeria, to his prejudice. Hence, his purported dismissal is unlawful, null, void, and of no effect. Again, claimant wrote appeal letters against his dismissal to the first defendant, but the defendant neglected, refused, or failed to react to same in any way. Thus, his instructions to solicitors instituting this action against the claimant in its submission has formulated 2 issues. They have argued and supported with authorities. The issues are: 1, whether the decision of the defendant as contained in their letter of 27 March 2019 titled dismissal, purporting to dismiss the claimant from his employment as a chief superintendent of police, in the Nigerian police force with effect from 27 March 2019 is in accord with the Constitution or law and the public service regulations governing the terms and conditions of service of claimant as to effectively determine said employment defendants. As earlier stated, I will go into the submission of counsel. I will just proceed to the decision of the courts. I stated earlier on, now the court's decision. I stated earlier on in this judgment that defendants filed no processes in this suit, despite having served with all court processes, including hearing notices. And as rightly pointed out by claimant counsel in his arguments, the implication here is that the defendant in the instant case will be deemed to have admitted the claim or relief in the statement of claim, which remain uncontested or challenged. And this is the principle of law. See Okeobo and police counsel, equal Stafford and county. The citations are all provided herein. Again, minimum evidence to be required in the instant case to prove the case by claimant succinctly put the court in the case of New Breed Organization Limited and Eromosele, 2000 PLR 1984 HC at 26. It is, however, also the settled position of law that the failure of defendant to defend the case cannot mitigate the duty of the claimant, which duty remain inviolate to prove its claim for declaratory release by credible, sufficient, and admissible evidence, whether or not it is defended by the defendant. Claimant is expected to succeed on the strength of its own case and not on the weakness of defense. See Access Bank versus Case International Limited, equal case of Alaribe and Okwonu. Upon the assessment of the pleadings of the claimant and totality of evidence adduced on record and the entire circumstances of this case, it is my considered view that the narrow issue for determination in this suit, not being mindful of the issues already formulated by learned counsel to claimant, can be tersely formulated as follows: whether or not, in the light of the uncontroverted evidence and documentary evidence before the court, the dismissal of the claimant was done in accordance with provisions of the law, and whether the claimant has proven his claims against the defendants to be entitled to the relief sought in this claim. The claimant, in support of his case, relies on the Police Act and regulations, the Constitution FRN 1999 as amended, and public service rules, and that his purported dismissal by first defendant is unconstitutional, invalid, ineffective, and amounts to a nullity for the failure of first defendant to comply with the requirements of Section 36 sub 1 of the Constitution and Rules 030302 to 030306 of the Public Service Rules 2000. It is evidence of claimant, both oral and documentary, that he was offered appointment to the Nigerian Police Force as Assistant Cadet Superintendent of Police, rose through the ranks as SP, and then to substantive rank of CSP before his dismissal by defendant. See Exhibit CA1, Letter of Appointment, CA2, Annual Performance Evaluation Reports, CA3, this wireless message on posting and transfer of police officers, this wireless message to presenters of claim, and CA6, pay slip of claimants at TSP on salary scale 3, 4, 6, and 7. Witness statement or notes of CW1 dated 5th day of July 2019. It is clear from the entire case of the claimant as presented before this court that he has relied on PSR, police regulations, amongst others, that he's a public officer. It is not in doubt also that the police regulation is a subsidiary of the Police Act 2004, which is the law relating to the instant case, which deals also with the appointment, discipline, and termination of employment of police officers, such as the claimant. And on this ground, I am convinced that the employment of claimant in the instant case is governed by statute, as I so hold. Although the police regulation does not specifically make provisions for disciplinary process as applicable to the allegations against the claimant, Be that as it may, Rule 160103 of the Public Service Rules 2009 edition, subsequently referred to as the PSR here, can be conveniently invoked to the effect that the PSR will apply in the absence of internal rules and regulations on any matter arising in this case. More so, defendant did rely on the PSR in dismissing the claimant. By Exhibit CA 13, dated 27 March 2019, the reference is quoted here. The claimant was dismissed by first defendant for alleged acts of misconduct and serious misconduct, and defendant relied on PSR 030302C and PSR 030307 and other extant rules. It is not contended that the defendants have such powers to dismiss the claimant in line with paragraph 30B, third schedule of the Constitution of the Federal Republic of Nigeria 1999, as amended, but then the dismissal must be in accordance with 030403 of the Public Service Rules, which stipulates that disciplinary procedure for serious misconduct shall be in accordance with rules 030, 302 to 030306 of PSR. Now PSR 030302C and 30307, which defendant relied upon in dismissal of the claimant, states thus, I quote, as soon as a superior officer becomes dissatisfied with the behavior of any officer subordinate to him or her, it shall be his or her duty to inform the officer in writing, giving details of unsatisfactory behavior, and to call upon him or her to submit within a specific time such written representations as he or she may wish to make to exculpate himself or herself from disciplinary action. After considering such written representations as the officer may make within the specified times, the superior officer shall decide A, B, and C, which defendants have relied upon. The officer has not exculpated himself or herself and deserves some punishment, in which case Rule 030, 304 shall apply. According to defendant by Exhibit CA 13 of 27 March 2019, paragraph 2, the commission, that is, First Disciplinary Committee, decided that claimant did not exculpate himself from disciplinary action. Defendant referred in Exhibit CA 13 to the First Disciplinary Committee report and the IGP's comments. There is, however, no evidence before the court to the effect that the claimant was confronted with any of the investigation reports used against him or that he had access to same. Claimant was not confronted with Exhibit CA 9 and CA 10, which were the police investigation reports respectively, dated 6 March 2013 and 18th March 2013, to enable him prepare his defense to the allegations upon which he was queried in Exhibit CA 4 and CA 11 on the allegations of serious misconduct. There is also evidence adduced by defendants to the effect that those who may have indicted or implicated the claimant were invited before the First Disciplinary Committee for the claimant to have the opportunity of putting questions across to such witnesses. In a case of dismissal of an officer whose employment is regulated by statute, as in the instant case, no documentary evidence shall be used against such an officer unless he or she has previously been supplied with a copy thereof or given access to same, which the defendant here failed or refused or even neglected to do in this case. Still, Rule 030307, 6 and 7 of the Public Service Rules, which defendants even relied upon in dismissing the claimant, and Exhibit CA 13. It is very glaring that defendants failed to comply strictly with the disciplinary process which they have relied upon in the Public Service Rules. The law is settled that once a panel concludes its inquiry and makes up its mind that any point had prima facie been made out, which points to the fault of any person, the employer must first inform such an employee of the case against him and give him the opportunity to refute, explain, or contradict it, or otherwise exculpate himself by making any representation or defense thereto, before the employer can lawfully use those points as basis for dispensing with his services. Defendants in this case must adhere strictly to the dictates of fair hearing, which is all that is required, and must follow the procedures set down in the Public Service Rules as applicable in the current case, in order to properly dismiss the claimant against whom conduct is alleged. Where such procedure is violated, an employer's order of dismissal will be inoperative and void. See Baba and NCATC 1991, 5N WLR Part 192 385, equally University of Calabar and SCN 1996, 10N WLR Part 477 225 at 262. SC, that's Supreme Court. The uncontroverted evidence adduced by CW1 is that when he appeared before the FDC, he was not informed of the allegations he was required to answer, nor availed the opportunity of seeing or hearing the evidence, oral or documentary, against him, or confronting any witnesses that may have testified against him, or even examine any documents, including the criminal investigation conducted which implicated him for misconduct. This is a further and uncontroverted evidence of CW1 that the FDC, which was supposed to be a neutral adjudicator, became the accuser, witness, and judge in its own cause, and that he was excused to leave the FDC without a hearing on any of the several allegations of misconduct on which he was queried, or those that might have informed of his arraignment before the committee. That he was being accused of fresh allegations of corruption, which were completely different from those he was confronted with in various queries. See paragraphs 18 to 20 and 21 of deposition of CW and his witness statement or note. Claimant hearing was confronted with fresh allegations of corruption, bribery, falsification, amongst others, which also formed the basis of his dismissal. Interestingly, defendants by the exhibit CA13, which dismissed the claimant, never considered that allegation in exhibit CA11, that is query of corruption against the claimant, in their exhibit CA13, which dismissed the claimant. This puts the claimant in the dark, and even the court, as to the specific wrongdoing alleged against the claimant for which he was dismissed. By rule 030307 sub 8, if during the course of inquiry, further grounds for dismissal are disclosed, as in the instant case, and the Federal Civil Service Commission, in this case, the First Disciplinary Committee, thinks it fit to proceed against the officer upon such grounds, the officer shall, by the direction of the committee, be furnished with a written statement thereof, and the same steps shall be taken as prescribed above in the original ground. In other words, the same steps taken on the initial or original grounds upon which claimant was queried shall also be repeated regarding the new grounds of allegation or offense. Exhibit CA13, paragraph 2, dismissal letter, states that the claimant has not exculpated himself. If that is the case, then it behoves on the defendants to proceed with disciplinary action, which shall only be in accordance with Rule 030, 302 to 306 of the Public Service Rules. This is where stated in Rule 030, 304 that disciplinary procedure for serious misconduct shall be in accordance with Rules 030, 302 to 306 of PSI. The FDC is bound to observe the rules of natural justice and not exempted from observing the principles of audi alteram partem and nemo judice in causa sua, enshrined in the rules of natural justice, which constitute the principles of fairness and are equally enshrined in Section 36(1), Constitution, Federal Republic of Nigeria, 1999. Where the FDC proceedings on documents to be used against the claimant in the instant case, the claimant must be heard on written documents and must be given also the opportunity of an oral hearing. Defendants in this case cannot conclude their investigations and dismiss the claimant on that basis and upon a purported IGP's comments or even FDC report. More so, there is no FDC report before this court to show the disciplinary process followed by defendants before claimant dismissal. In all, this court faults the procedure adopted by defendants in the instant case in dismissal of the claimant, which was not done in accordance with the provisions of the law, and I so hold. It is clear that most of the allegations against the claimant upon which he was dismissed were tainted with criminality, and the Supreme Court in CBN and Dine 2021 15 NWLR Part 1798 at 91 has held thus: where there is an allegation of criminal wrongs against the person, the jurisdiction to determine the allegation is vested in the courts, and the exercise of jurisdiction cannot be usurped by any administrative tribunal. The reason is simple. Where there are serious allegations of fraud and forgery, the matter is beyond the power of an administrative panel. It has to be pronounced upon by the courts of law, as the allegations have serious nature, requiring proper judicial processes in all their ramifications. In this case, the respondent was accused of misconduct amounting to criminal offense. In the circumstance, the trial court and the Court of Appeal rightly found that the respondent should have been tried by the ordinary court before his dismissal from employment, unquote. Flowing from above, there is nothing before me to show that defendant resorted to the court of law to determine the criminal allegation against the claimant before reaching his decision to dismiss the claimant. It is tried that where an employer profiles a reason for termination of employment, the law imposes on such employer the duty to establish reason. See SPDC and Olanrewaju, 2008, 18 NWLR, Part 1118, at 1, Supreme Court, equally Savannah Bank, PLC, and Fakokun, 2002, 1 NWLR, Part 749 at 544. Since my finding again that defendant having failed to institute an action against the claimant before an ordinary court regarding the criminal allegations, which eventually led to his dismissal, has failed to establish the reason before this court. It is on this ground that I find the dismissal of the claimant by defendants null and void, and I so hold. Be that as it may, dismissal of claimant in the instant case was without strict recourse, as I earlier on stated, to or in manner with the applicable rules, regulations, statutes of appointment of the claimant. Also, it is not clear that the rules 030303 to 030306 on disciplinary procedures were considered at all by defendants in this case. There can be no gainsaying the fact that these public service rules have been formulated in such a way as to avoid injustice, but they have flagrantly disregarded in this case of the defendant, who have also failed or neglected to defend this suit against them. All that the claimant had were queries and its replies thereto, which are exhibits CA4, CA7, and CA8, amongst others. And the next was exhibit CA13, dismissal letter served on him without being given a fair hearing before the first disciplinary committee set up against the claimant. It is clear that the FDC acted solely on its report and the IGP's comments, if any, exhibit CA4, CA7, and CA8, which are queries and replies to them. From these facts, it is deducible that the dismissal of claimant's hearing was not in accordance with the provisions of the public service rules. Having reached that conclusion, and in view of the fact that defendant's office is obviously one with a statutory flavor, I must apply the principles of many decided cases, namely Emmanuel Okeme and Civil Service Commission, Edo State, and others, Professor Olaniyan and University of Lagos, Ekperokun and University of Lagos, Shitabe and Federal Civil Service Commission. The citations are all provided. If I apply these principles, I must thus conclude that the claimant was entitled to a fair hearing, but was not given one. On this ground alone, I must declare his dismissal via the CA3 null and void, and I so hold.
Wow.
Having declared claimant's dismissal null and void, what then will the claimant be entitled to, and whether he has proved his entitlements to the relief sought in this suit against the defendants? The claimant hearing whose dismissal the court has held to be null and void will be entitled to an order of reinstatement. And reinstatement, in the words of Tucker J., involves putting the specified person back in law and in fact in the same position as he occupied in the undertaking before the employer terminated his employment. Once an act is declared to be a nullity, following the detection of fundamental vice, as happened here, it is null and void, and it is as if that act has never taken place before. See Abilawon, Ayisa, and Olaoye Akanji, and 25 others, Olorun Toba Ojo and others versus Abdurrahim and others. Citations are all provided. I have read the reliefs of the claimant which have been reproduced earlier on in this judgment. It is tried that the claimant seeking declaratory reliefs must adduce cogent and compelling evidence to prove the entitlement to relief sought, as the claimant's case will be determined solely on the strength of his case and not on the weakness of defendant's case. Odera Investment Company Limited and EcoBank, Falake and INEC, amongst other cases cited here. It is my finding that claimant in this case has established that his dismissal by defendant was without recourse to the provisions of the law. Thus, it is unconstitutional, null and void. He has further established by Exhibit CA5, reference DTO 131825/05/2016, that he was promoted to the rank of Chief Superintendent of Police before his dismissal by defendants, contrary to the wrong ranking accorded the claimant by defendants in their dismissal letter of 27 March 2019, wherein they refer to claimant as SP instead of CS. The claimant has further proven by exhibit CA6 payslip that as of December 2018, he was on net pay salary of 170,101.64 kobo on grade level 12, step 8, and as Chief Superintendent of Police. In all, the claimant succeeds in his reliefs 1, 2, 3, 4, 5, 7, and partly in his relief 6 of his complaint and statement of facts. And for the avoidance of doubt, this court declare and orders as follows. 1. It is declared that the dismissal of the claimant by exhibit CA13, dated 27 March 2019, is unconstitutional, null, void, and of no effect whatsoever, and it is hereby set aside. That the claimant is yet as Chief Superintendent of Police and entitled to remain so, following the order of this court reinstating the claimant, and this is without prejudice to the claimant's promotion and or increment in accordance with the extant regulations until his appointment is lawfully determined in accordance with the provisions of the law as applicable to the claimant. 3. It is declared that the claimant shall be entitled to all his emoluments, entitlements, allowances, and other privileges as applicable to his rank in the service of the Nigerian Police Force until his appointment is lawfully terminated. 4. It is the order of this court that the defendants, their agents, their servants or agents shall grant, avail, and pay the claimant all accrued and accruing salaries, emoluments, benefits, allowances, etc. from the 27 March 2019, when claimant was dismissed from office, until date of this judgment and satisfaction thereof. 5. Defendants, their servants or agents are restrained from the date of this judgment from further withholding the salaries, emoluments, entitlements, promotion, where applicable, of the claimant until its appointment is lawfully determined. 6. Of 100,000 naira in favor of claimant against
We are so much grateful, my lord, for this well-educated and deserved judgment. Thank you very much, my lord.
All
we are
right.
so much grateful.
That is all regarding